good day, ma'am. So my topic for today is about the labor relations in Chapter 11. So labor relations, Book 5 of the Labor Code on Labor Relations was amended by RA 6715, which affected on March 21, 1989. Article 211 of the Labor Code as amended states that its policy of the state first is to promote and emphasize the supremacy of free collective bargaining and negotiation, including voluntary arbitration, mediation, and conciliation as a mode of settling labor or industrial disputes. So meaning, this states that prioritizes the negotiation between the workers and employers to resolve disputes peacefully through voluntary methods like what I've said earlier, the abbreviation, mediation. So this ensures that labor conflicts are settled fairly without escalating. So second is promote free trade unionism as the instrument for enhancement of democracy and for the promotion of social justice and development. So means that encouraging trade unions enhances democracy by giving workers a collective voice, so promoting their social justice and fostering national development. So third, to foster the free and voluntary organization of a strong and united labor movement. So meaning the state that supports the voluntary formation of labor unions. So to strengthen workers' solidarity, and protect their rights effectively. So the fourth is to promote the enlightenment of the employees concerning their rights and obligation as a union members and as an employees. So meaning that education employees about their rights and responsibilities now as a union members. So and workers also empowers them to advocate for fair treatment and better working their conditions. So fifth is to provide and advocate administrative machinery for the expeditious settlement of labor or industrial disputes. So meaning that establishing system and institution is helped to settle the labor disputes quickly and efficiently, and also ensuring that this stability in labor relations. Six is to ensure stable but dynamic and just industrial peace. So meaning that the goal is to maintain a balance between employees and employers. So interest also. So this fostering a work environment that is both fair and productive. So the last one is to ensure the participation of workers in decision and policy making processes affecting their rights and duties and welfare. So meaning that employees is encouraged to take part in decision and also the policies that directly impact their rights, duties, and also an overall well-being in the workplace. So next one is the policy on fixing of wages and benefits. So to encourage a truly democratic method of regulating the relations between the employers and the employees by means of agreement freely entered into through collective bargaining, no court or administrative agency or official shall have the power to set or fix wages and rates of pay, hours of work, and also our terms and conditions of employment, except as otherwise provided under this code, according to Article 211 Labor Code as amended. So meaning that, what I've said earlier, the Labor Code's Article 211 is the collective bargaining and also prohibiting courts and agency from interfering with employee agreements on wages, rates, pay, and hours of work, and also unless specified exceptions apply. So for example, a workers' union negotiates with their employer for higher wages and reduce working hours, so resulting in an agreement that satisfies both parties without outside interference. So next one is National Labor Relation Commission or NLRC. So meaning there shall be a National Labor Relation Commission or NLRC which shall be attached to the Department of Labor and Employment or DOLE for program and policy coordination only. So nag-compose ni siya og 14 members. So ang 5 members each shall be chosen from among the nominees of the worker and employers organization respectively. So other one is the chairman and other 4 members shall come from the public sector to be recommended by the Secretary of Labor and Employment. So upon assumption of office, the members is nominated by the workers and employers para shall divest themselves of any affiliation with the organization to which they belong. So I have a sample. So companies workers file a complaint about unfair labor practices. So ang NLRC daw is mediates and resolve so any disputes between employees and employers. So bali na kung ano din siya. So next one is the administration and performance of functions. So the Commission shall set in bank only for purposes of promulgating rules and regulation governing the hearing and disposition of cases. So however, in the performance of its adjudicatory powers, the Commission may set in 5 division of 3 members. So 5 division is ang first, second, and third division shall handle cases from coming the NCR or the National Capital Region, and also in part ni siya sa Luzon, and also in the 4th and 5th division is galing siya sa Visayas and the Mindanao. So provided further, the Commission setting in bank may allow cases from other division to be heard and other division on temporary and emergency basis, and according to Article 213 of the Labor Code as amended by 6712. So for example, ang labor case is nasa Luzon, so ang Luzon is can temporarily be transferred to the Visayas division if the Luzon division is overloaded with cases. So the next one is adjudication of cases by the Commission. So the encounters of 2 commissioners of a division shall be necessary for the pronouncement of judgment for resolution. So whenever the required members in a division cannot be obtained, the chairman shall designate such commissioners from other division as may be necessary. So the conclusion of a division on any case submitted to it for the decision shall be reached in consultation before the case is assigned to a member for the writing of opinion. It shall be mandatory for the division to meet for the purpose of consultation as herein prescribed TBD. So meaning ang labor dispute resolution requires a quorum of 2 commissioners. So if needed though, the chairman may assign commissioner from other divisions. So for example, if a division has only 1 commissioner present due to illness or other reasons, so the chairman can appoint another commissioner from a different division to ensure na ang case daw is nag-proceed via condition of stock. So the next one is presiding officer of the commission or division. So the chairman shall be presiding officer of the first division, and the other 4 members from the public sector shall be the presiding commissioners of the second, third, fourth, and fifth divisions. So in case of absence or incapacity of the chairman of the commission, the presiding officer of the second division shall be the acting chairman. So if like what I said earlier, now if the chairman is absent or unable to perform those duties, so the presiding commissioner of the second division is temporarily assumes the role as a acting chairman. So next one is the headquarters, branches, and provincial extension units. So the commission its first, second, and third division shall have their main offices in Metro Manila. So in the fourth and fifth division, it shall have their offices also in the cities like Cebu and Cagayan de Oro. So the commission shall establish as many regional branches as there are regional offices of the Department of Labor and Employment, and also sub-regional branches or provincial extension units may also be established. There shall be as many labor arbiters as may be necessary for the effective and efficient operation of the commission. So each regional branch shall be headed by the executive labor arbiter. So the National Labor Relations Commission or NLRC has main offices, what I've said earlier, Metro Manila, national main offices, and also the Cebu and Cagayan de Oro na po yung mga other. So next one is qualification of the commissioners, labor arbiter. The chairman and other commissioners shall be a members of the Philippine Bar and must have been engaged in the practice of law in the Philippines with at least 5-year experience of exposures in labor management relations, and probably must be a resident in the region where they are to hold office. So the executive labor arbiter and other labor arbiters shall likewise be a members also of the Philippine Bar with at least 3 years experience of exposures in labor management relations, and according to Article 215 in Labor Code as amended. So the next one is appointment. The chairman of the commission and the other commissioners shall be appointed by the president without confirmation siya lang jud ang maka-appoint kung kinsa. So by the commission on appointment. So the executive labor arbiter and other labor arbiters shall be appointed president in accordance with the civil service rules and regulations. So next one is the security of tenure. The chairman and other commissioners, including the executive labor arbiter and the labor arbiters as well, shall hold office during good behavior until they are age of 65, unless sooner removed for cause or incapacitated to do the duties of their office, according to Article 211 of the Labor Code as amended by RA 6715. So meaning that the Philippine President appoints the NLRC chairman and commissioner without needing confirmation from the Commission on Appointments. Next is vacancy. Appointment to any vacancy shall come from the nominees of the sector with nominated the predecessor. So meaning the vacancies of the NRC are filled from nominees of the same sector that nominated what I've said earlier, the predecessor. Next one is appoint of staffs and personnel. The Secretary of Labor and Employment in consultation with the chairman and other commissioners shall appoint staffs and personnel of the commission, including its regional offices as a means of the service may require subject to the civil service rules and regulations. So meaning that the Secretary of Labor and Employment now is consulting with the NLRC's chairman and commissioner is appoint their staff and personnel based on service needs and also following civil service rules. Next is salaries, benefits, and emoluments. The chairman and other commissioners shall receive an annual salary at least equivalent to and be entitled to the same allowances and benefits as those of presiding justice and associate justice of the Court of Appeals, respectively. While the executive labor and labor arbiters is also shall receive an annual salary same sa chairman commissioners at least equivalent to and be entitled also to the same allowance and benefit as those of the assistant regional director of the DOLU, and according to Article 216 Labor Code as amended by RA 6715. So next one is the jurisdiction or the powers of labor arbiters. So except as otherwise provided under this code, the labor arbiters shall have original and exclusive jurisdiction to hear and decide within 30 calendar days after the submission of the case by the parties for decision without extension. The following cases involving all workers whether agricultural or non-agricultural. So mo ni siya ang mga cases, no? So first is unfair labor practices cases. Second, termination disputes. Third is if accompanied by the claim of reinstatement. So those cases that workers may file involving rate of pay nila, tapos hours of pay and condition of works. Fourth, claims for actual, moral, exemplary, and other forms of damages arising from employer-employee relationships. Fifth is cases arising from any violence of Article 264 of the Labor Code, including questions involving the legality of strikes and lockouts. And lastly is exact claims for employees' compensation, so social security, Medicare, and maternity benefits. So all other claims arising from employer-employee relationships, so including those of person in domestic or household service involving an amount of exceeding 5,000 pesos, so regardless of whether accompanied with a claim of reinstatement, in according to Article 217 of the Labor Code as amended. So next one is powers, jurisdiction of the Commission or NLRC. The Commission shall have powers and authority as follows. First, the Commission shall have exclusive appellate jurisdiction over all cases decided by the labor arbiters. Second, promulgate rules and regulations governing the hearing and disposition of cases before it and its regional branches, as well as those pertaining to its internal functions and such rules and regulations as may be necessary to carry out the purpose of the code. Third, to administer oaths, issue a subpoena, summon the parties to a controversy requiring their attendance and testimonies of witnesses pertaining any matter under investigation of hearing conducted pursuant to this code. Fourth is to conduct investigation for determination of question, matter of controversy within its jurisdiction, and dispose of the same as may be necessary under the law. And fifth is to hold any person in contempt directly or indirectly and impose appropriate penalties therefore in accordance with law. And lastly, to enjoin or restrain any actual or threatened commission of any or all prohibited or unlawful acts, or to require the performance of a particular act in any labor disputes which, if not restrained or performed, so may cause grave or irreparable damage to any party or render ineffectual any decision in favor of such party. So provided that no temporary or permanent injunction in any case involving or growing out of a labor dispute as defined in this code shall be issued except after hearing the testimony of witnesses with opportunity for cross-examination in support of an allegation and a complaint made under oath, and testimony in opposition thereto if offered, and only after finding of fact the commission needed to that effect. So first is that prohibited or unlawful acts have been threatened and will be committed and will be continued unless restrained. Second, it's substantial and irreparable injury to complainants. Property will follow that as to each item replied to be granted, greater injury will be inflicted upon them. Lastly, of the complainant, if relief is denied compared to that injury inflicted upon the defendant. Next, the complainant has no remedy at law. And last one is that the public officer charged with the duty to protect complainant's property are unable and or unwilling to furnish adequate protection in according to Article 1 Labor Code as amended. Next one is the ocular inspection. The chairman and commissioner labor arbiter or the duly authorized representatives may at any time during working hours conduct an ocular inspection on any establishment, building, ship or vessel, place or premises including any work, material, implement, machinery, appliance or any object therein, and as any employee or labor data or datus. Concerning any matter in question relative to the object of the investigation in according to Article 219 Labor Code as amended. So meaning no, ang NLRC officials, chairman, commissioner, labor arbiters, or representative can conduct on-site inspection, so of workplace during working hours to gather information, and also they are investigating the labor disputes. Next one is technical rules not binding. In any proceeding before the commissions or any of the labor arbiter, the rule of evidence prevailing in courts of law or equity shall not be controlling, and it is key spirit and intention of this code that the commission and its member and the labor arbiter shall use every and all reasonable means to ascertain the facts in each case speedily and objectively and without regard to technicalities of the law or procedures, all in the interest of due process and according to Article 221 Labor Code as amended. So meaning, ang NLRC is and labor arbiters is nag-prioritize of fairness and speed over technical legalities, using flexible procedure to objectively and also determine facts. Services of counsel is required. So in any proceeding before the commissioner or any labor arbiter, the parties may be represented by legal counsel, but it shall be the duty of the chairman, any presiding commissioner or any labor arbiter to exercise complete control of the proceedings in all stages. So meaning, like, parties may have legal representation. So but the NLRC as the chairman, commission or labor arbiters maintain o nagakontrol sila over proceedings. Next is preference for amicable settlement. Notwithstanding of any provision of law to the contrary, the labor arbiter shall exert all efforts towards the amicable settlement of a labor dispute within his jurisdiction or before the first hearing. The same rule shall apply to the commission in the exercise of its original jurisdiction. So meaning that labor arbiters o ang commission is mas nag-prioritize the amicable settlements of labor disputes so during or before the first hearing. Next one is appearance and fees. Non-lawyers may appear before the commission or any labor arbiter only. So first is if they represent themselves or if they represent the organization or members. So thereof, no attorney fees. So negotiation fees or similar charges of any kind arising from any collective bargaining negotiation or conclusion of a collective agreement shall he impose on any of the individual member of the contracting union. So provided, however, that attorney's fees may be charged against union funds and an amount to be agreed by the parties. So any contract, agreement, or arrangement of any sort to the contrary shall be null and void in according to Article 222 and Labor Code as amended. So next is appeal. Decision, awards, or orders of labor arbiter are final and executory unless appealed to commissions by any or both parties within 10 calendar days also from receipt of such decision, awards, or orders. So such appeal may be entertained only upon any or all the following grounds. First, if the decision, order, or award was secured through fraud or coercion, including graft and corruption. So next is if there is a prima facie evidence of abuse of discretion on the part of the labor arbiter. Third, if made purely on question of law. Fourth, if serious errors in the finding of facts or raised which would cause grave or irreparable damage or injury to the applicant in according to Article 223 Labor Code as amended. So appeal with employer on the monetary awards. So in case of judgment involving a monetary award, an appeal with the employer may be perfected only upon the posting of a cash bond or surety bond issued by a reputable bonding company duly accredited by commission in amount equivalent to the monetary award and the judgment appealed from. So meaning, an employer must post a cash or surety bond equal to the monetary award. So to perfect the appeal against a labor judgment. Reinstatement aspect is immediately executory. In any event, the decision of labor arbiter reinstating a dismissed employee as so far as the reinstatement aspect is concerned shall immediately be executory and pending appeal. The employee shall either be admitted back to work under the same terms and conditions prevailing prior to his dismissal or separation to work at the option of the employer merely reinstated in the payroll. So the NLRC decision is appealable to CA. The period of matter of appeal from the NLRC to the Court of Appeals is by petition for review under Rule 65 of the Rules of Court pursuant to the ruling of St. Martin Freunde Homes versus NRCL 295 SCRA 494. It states that a petition may be filed not later than 60 days from notice of the judgment or resolution sought to be assailed. So Next is motion for reconsideration of the NLRC decision as mandatory requirement. The filing of a petition for certiorari under Rule 65 with the first moving for reconsideration of the assailed resolution warrants the outright dismissal of the case. As consistently held in numerous cases, a motion for reconsideration is indispensable for it affords the NLRC an opportunity to rectify errors or mistakes it might have committed before sort to the court can be had in according in a real case to Viloso versus China Airlines LTD 310 as CRA 274. So meaning no that ang filing a petition for certiorari under Rule 65 is without first seeking the reconsideration with the NLRC will result in automatic dismissal. So as reconsideration is a required step. So where the order of reinstatement was reversed on appeal, even if the order of reinstatement of the labor arbiter is reversed on appeal, it is obligatory upon the employer to reinstate and pay the wages of the dismissed employee during the period of appeal until reversed by the higher court. On the other hand, if the employee has been reinstated during the appeal period and such reinstatement order was reversed with finality, the employee is not entitled to reimburse the salary he received, for he is entitled to such more so if he actually rendered services during the period. So meaning the employer must reinstate and pay dismissed employees during appeal. So, but if the reinstatement is later reserved, so employees retain earned wages for services rendered. So next is certiorari under Rule 65, although even an RCU decision has become final and executory. So the fact that the RCU decision has become final and executory after 10 days before period does not preclude the adverse party from challenging it. So by way of an original action for certiorari under Rule 65 of the Rules of Court. So he may even further pray for the issuance of a restraining order or temporary injunction to prevent the immediate execution of the ASEL decision. So meaning, even after the decision becomes final and executory, so the opposing party can still challenge it through a statutory petition, so claiming grave abuse of discretion or irregularity. So a party can request a restraining, so order a temporary injunction to halt enforcement of a decision while appealing. Next is effect of forum shopping. If the cause of the party or his conciliatory constitute will full and deliberate forum shopping, the same shall be a ground or for summary dismissal with prejudice and shall institute direct contempt as well as a cause for administrative sanction. So meaning, willful and deliberate from forum shopping is or filing multiple cases in different courts to obtain a favorable ruling. So may result in summary dismissal, so contempt charges and also administrative sanctions. And the lastly, verification. A petition for review and certiorari under Rule 65 of the Rules of Court must be verified by an affidavit that the applicant has read the pleading and the allegations therein are true and correct of his personal knowledge or based on authentic records, LDP Marketing and Lourdes Pena versus Linda Monter. So there is substantial compliance if verification is executed by an attorney. So according to verification, a petition for review under Rule 65 must be verified by affidavit confirming the allegations truth. So either first-hand or from authentic records. So although attorney verification suffices for substantial compliance. So thank you for listening, and that's all, ma'am.